Well, in order to make it easier to remove failed asylum seekers, the government also intends to change the way the European Convention of Human Rights and Modern Slavery Act is applied. Now, we're speaking to Professor Veronika Fikfak about this now, a professor of human rights and international law at the University College London. Morning, Veronika. Thank you for your time. There's been a lot of confusion about this. There's also been a lot of different opinions as to what needs to happen in order to ensure that these proposals by Shabana Mahmood are able to go through seamlessly and also rather quickly as well. So my first question to you is, does this new policy still work under the European Courts of Human Rights?
Yeah, so what the government is essentially proposing is two parts to its strategy. One is a domestic and the other one is an international one. On the domestic front, what the Home Secretary suggested is essentially to give domestic courts that are the first organs to apply the European Convention of Human Rights, to give English courts, English judges instructions on how to interpret and apply the convention. And that includes really limiting who family members are. So it's not going to be uncles and cousins. It would be parents and children. To apply a public interest test. Does that mean that it is in the public interest to allow a person to come into the country? So really to tighten and to narrow that application of the law domestically. And then there's the international element to the proposal, and that is to go to Strasbourg, to sit down with other 45 countries of the Council of Europe, and essentially to agree a new interpretation of Article 3 of the European Convention of Human Rights that relates to degrading treatment. But together, the plan or the hope of the Home Secretary is that this Danish option, as it's called, would work to bring immigration down.
I'll come on to the Danish system in a moment, but you mentioned the international courts. I think that is the sticking point that a lot of people, including Kemi Badenoch, and she was speaking yesterday, was talking about. Is that something that is going to be possible to reinterpret Article 3 and Article 8 and take that to Strasbourg?
So one of the things that I think the Home Secretary gets absolutely right is that the convention is primarily applied by domestic courts around the Council of Europe. So in 46 countries, different judges, domestic judges, will be applying this Article 8 in different ways. And what the Strasbourg court does is it only sets limits. And what the Home Secretary is doing now is she's tinkering with more than the minimum. She is going after how domestic courts are applying this. On the international front, what they're trying to do is really ask the Strasbourg court, ask judges in Strasbourg to be a bit more strict about how they interpret the idea of degrading treatment or inhuman treatment. So to say that there are fewer situations in which we would need to keep migrants in the country because they face a high risk of inhuman and degrading treatment if sent back. So this is only related to expulsion. And that's a declaration that countries come together and they write it, and it is addressed to the court, and it guides the court in its interpretation of the case law later on.
You mentioned the Danish system there, and the government have been looking closely at that system to operate quite a much tougher stance whilst also remaining in the ECHR, as Denmark have done. Now, you serve as a judge. Is it a case that the UK need to change how they interpret the convention, and how have Denmark been able to do that?
So Denmark has used this option, and I think a lot of what is in this proposal is very much a copy-pasting or an application of what Denmark has done in relation to the convention. So the Danish judges do have these instructions to be quite narrow in their application of Article 8. There's also an instruction to Danish judges to, unless they're absolutely sure Denmark would be in violation of the convention, to be much narrower and to if there's a violation, Denmark is prepared to go and defend these judges in Strasbourg. And that's that looks like the trajectory on which the UK now is or is planning to go. But I think this will depend very much on how it's implemented. So will the English judges and English organs or authorities have buy-in to apply this legislation as it has been suggested? How will they understand public interest test?
So there does seem...
Yeah.
There does seem to be a precedent there with how Denmark have implemented it for the UK to copy. A lot of people, many people, including on this programme yesterday, have been calling for the UK to remove themselves from that convention completely in order to make those changes, and saying the only way that we're going to be able to get this through is by leaving the ECHR. Is that necessary?
No, I think that's a bad idea for a number of reasons. One of them being that even if we were to leave the European Convention on Human Rights, there are other international laws that that provide the same protection. And so we would then be applying other international laws, and English judges would be doing that. So withdrawing from the European Convention is not a solution. And I think Strasbourg Court in this context is really keen to hear what countries have to say and how they would like the convention to be reinterpreted. So I think this route is a much a wiser route, also because it can be achieved, the interpretive declaration can be achieved in 6 months to a year.
Yeah, others will say that this is the only way to do it, and in a way that would be also effective and efficient and speedy as well. So thank you very much for your time, Professor Veronika Fikfak, a Professor of Human Rights and International Law at University College London. It is 14 minutes past 7.